Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk, the most fact-driven, unbiased, true crime channel. First on the docket, this is an example of why Mark Means must go as counsel for Lori Vallow. Second, a California man does the unspeakable. Are police making any progress in locating Summer Wells? An example of how not to evict somebody. An update on the spring break killers, and then finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for watching. You know the drill. If you haven't done so already, please hit the subscribe button, hit the like button, and don't forget to hit that bell so that you receive notifications of when we go live or put up new content. Let's get straight to the docket today. Why Mark Means has got to go. Now, as we talked about the other day, the court, on its own motion, appointed a new attorney for Lori Vallow. His name is James Archibald. We talked about him the other night. He is an experienced criminal defense attorney and has been a public defender, so he knows the system and he's handled several serious cases, and he's one of the few attorneys that is death qualified, and I mean death qualified in the sense that he's done death penalty cases there in eastern Idaho. It would make sense that he would be the lead attorney on this case from here on out. Mark Means should simply sit down, shut up, and please don't say a word, and pretty please don't file any more motions. And that is what brings us today to why he has to go. As I was looking at the new motions filed by Mr. Means, I literally want to just shake my head and say, this is why people don't like attorneys. This is why people don't like attorneys, because they think they file frivolous crap motions that have no basis in the law or fact, and therefore they file crap. If the court was concerned about Mr. Means being able to handle a complex criminal case, this should be Exhibit A in that order and motion. Mark Means filed a motion dated August 11th, and it's captioned, "Declared motion to dismiss the grand jury indictment." Well, I'm figuring a motion to dismiss the grand jury indictment, there must be some error in the grand jury indictment, something that was done improper which would throw it out. Oh, no. Mark Means came up with a novel idea, one that I don't think anyone would have thought of except for Mark Means. Why is he asking for the grand jury indictment, right? A grand jury indictment alleging murders of Lori Vallow's two children and the involvement with the death of Tammy Daybell, right? Pretty serious. You think a court's going to dismiss that unless it is outright totally egregious? No, they're not. They're not. Well, Mr. Means says he wants the proceedings dismissed against his client, dismiss the indictment. Why? Because he says that the prosecutor attempted to set a date in this matter, knowing full well that these matters were stayed because Lori Vallow was going off to the state hospital to be restored to competency. He states that there is no plausible argument regarding this blatant violation of the court orders to stay the proceedings, and that conduct was in direct violation of the court's orders to stay the warrant issue of dismissal of the above case. And he wants sanctions, right? He wants sanctions. He wants costs and fees to be issued against the state. Okay, let me tell you something. First of all, the appearance, although it's never really referenced as to what appearance he's referring to, one would have to assume it was the first appearance where Lori Vallow had been found not competent in the other proceedings regarding the tampering with evidence case, that's where it was stayed. The new case, which would have been the first advisement saying there's an indictment alleging all these new charges, you may recall we put that up for you as it related to Chad Daybell. That was the proceedings. There was nothing at that point issued in this particular case staying those proceedings until that time. The state did nothing wrong, in my opinion. And to ask for costs and fees associated with this is absolutely ridiculous. Okay, Mr. Means, I have never seen fees imposed against a defense counsel, let alone a prosecutor, for conducting business before the court. Not in a criminal case. Never a prosecutor. Never, ever a prosecutor. But this is the kind of stuff, the games that people play when it comes to civil work. And yes, my firm does civil work. And I'll be honest with you, I hate civil work. Why? Because this is the example of what civil litigators do oftentimes. It's always looking for a gotcha against the other side to try and ask for costs and attorney's fees to be imposed. You don't do that in the criminal world. It just doesn't work that way. And there's nothing that would warrant the dismissal of the indictment based upon this argument. In fact, Mr. Means cites no authority whatsoever that would state that this was in violation of anything other than he says is the court order, or any authority given the court the authority to dismiss the indictment. Indictments are dismissed for errors in the proceedings themselves, or if they lack probable cause. Those are the only reasons why they would be dismissed. Mr. Means has no clue what he's doing, and he needs to get off of this case. Hopefully, Mr. Archibald will come in and say, I'm in charge now. Sit down, shut up. You are basically qualified to get me a cup of coffee. That would be about it. And not to be outdone by that frivolous motion, Mark Means has filed additional motions to compel the prosecution to comply with his Rule 16 requests. And guess what? Well, those proceedings have been stayed, Mr. Means. And once again, it's the same issue where he simply has to go and pick up the discovery. I'm not sure what Mr. Means thinks he is accomplishing by this. He has some free time on his hands, apparently. Maybe spend a little less time allegedly visiting the state hospital, and maybe a little more time trying to get the discovery so he can assess the case against his client. Mr. Means needs to go. Next on the docket, a California man does the unthinkable. Matthew Coleman has been charged with the death of his 2 children. Now, the affidavit relating to the charges in this particular case, well, this is an example of how an affidavit needs to be done. It is very straightforward. It was written by the FBI, and it is a double homicide in this particular case, and it took up a total of 9 pages, most of that being introductory information. Well, for those of you who haven't heard this particular case, let me give you the summary, and I will give it to you straight from the affidavit, the summary for probable cause. On August 7th, 2021, M. Coleman took his 2 children, R.C., 10 months old, and K.C., 2 years old, from the home he shared with his wife and mother of his children, A.C., in Santa Barbara, California, to Rosarito, Baja California, Mexico. While in Rosarito, M. Coleman murdered his children by shooting a spear fishing gun into their chests. On August 9th, 2021, during a Mirandized interview, M. Coleman confessed to the murders. That is a summary of an affidavit, in this particular case, of a double homicide. It took 9 pages in which to lay out all the details, and in those detailed 9 pages, the FBI was able to lay out what Mr. Coleman did. The FBI was also able to lay out why Mr. Coleman did what he did. He thought that his wife had serpent blood in the DNA, and therefore the children would have it, and therefore they had to die. Apparently, Mr. Coleman was a member, or was enlightened by QAnon, as well as the Illuminati, which is why he thought that there were serpent blood DNA in his children and his wife's blood. Well, when Mr. Coleman returns from Mexico, he will be charged with a violation of 18 United States Code Section 119 and 1111, foreign murder of United States nationals. He's looking to spend the rest of his life in prison and probably a quick stop to the psychiatrist to determine whether he is in fact competent. They may go one step further to try to determine if Mr. Coleman suffered from a mental disease or defect, which would impair his ability to establish right from wrong, hence setting up a potential not guilty by reason of insanity defense. Next on the docket, are the police looking for Summer Wells making any progress? Well, according to the Tennessee Bureau of Investigation, not much. Apparently, no one is a suspect, but everyone is a suspect, and it has now been 8 weeks since Summer Wells has disappeared, and the police apparently are no further along in locating Summer Wells than they were 8 weeks ago. Now, the investigators in this case would ask that people only share information if it comes from an official source, i.e. them, and not put out speculation, which creates bogus leads that the investigators have to go investigate, which wastes their time if it's not based on anything in substance or fact whatsoever. The investigators are asking that people only share information from official sources because when they share speculation, it leads to false leads. Well, the police don't know they're false leads until they go check them out. But of course, that wastes time and they're not then pursuing legitimate leads. So as we try to do, let's keep the speculation to a minimum and let's focus on facts and hopefully they can find Summer Wells. But let's be candid. Obviously, as the more time goes by from her disappearance, the less likely they are going to find her. If anyone has any information about the disappearance of Summer Wells, please contact the police. All right, let's take a quick recess. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. All right, next on the docket. This is how you do not evict somebody from your property. As many people know, there has been a moratorium put in place that basically prevents landlords, as it relates to residences, from evicting tenants. I still am not exactly sure how the government, whether it be state or federal, can interfere with private contracts among individuals to say that we're now a party to it and basically voiding the other side's remedies for non-payment. Makes no sense to me. The United States Supreme Court was going to rule on it and basically say that you couldn't do that, but they said we're not going to rule on it because the moratorium was going to end. And well, guess what? Then they put it back in place. Makes no sense. Completely illegal. That's all pretty much what the Supreme Court said. You can't do it. But we had these in place here in Colorado where you could not evict anybody. The courts wouldn't hear the case, and they wouldn't hear a case challenging the orders as well. All right. That being said, Arnoldo Sanchez, 78, was renting a couple of rooms in his house. Individuals in his house were not paying their rent. He was upset. People advised him that he had to go to court to evict the individuals. Most people don't know that. If you invite somebody over to your house to sleep on your couch or in your room and they don't leave, you can't just kick them out the front door. You actually have to evict them. I know, it's hard to believe, but it's true. Well, in this particular case, Mr. Sanchez said, oh, no, I'm not going to go to court. I am going to handle it my way. And how did he handle it? Well, he wound up handling it by shooting 2 individuals and seriously wounding the other. The individual that survived had 9 gunshot wounds in this particular case. Needless to say, Mr. Lozano eventually surrendered once the police arrived. Now he's being charged with 2 counts of murder and 1 count of attempted murder. I'm telling you, go to court, ladies and gentlemen. You can't do these self-help remedies. You can't be the vigilante. You simply cannot do it. Eventually, Mr. Sanchez was surrounded by the police, and he ultimately surrendered. And now he's facing 2 counts of first-degree murder and 1 count of attempted murder. You simply can't do this, ladies and gentlemen. Although Mr. Sanchez is old, 78, I can't imagine his dying days. He would rather spend them in prison, and I just do not get why he did what he did. But human nature, ladies and gentlemen. That's why there'll always be a need for criminal defense attorneys and the police because, well, human nature, ladies and gentlemen. People will react. People will do the most bizarre, crazy things you can ever imagine, and you can't explain it, but it's human nature. Next on the docket, remember the spring break killers? That's right. Christine Engelhardt was the victim of the alleged murderers in this particular case, Evior Collier and Dorian Taylor. Now, they were both from North Carolina, but they were on their way to Florida to begin their music careers. Along the way, they met Miss Engelhardt at a bar. They took her back to her hotel room where they sexually assaulted her. She ultimately was found half naked, unresponsive, and she was missing her personal belongings, like her credit cards. Mr. Collier and Mr. Taylor obviously are not gentlemen at all. In fact, Miss Engelhardt ultimately passed away, and they were arrested for the murder. Well, a grand jury has filed charges against these two for first-degree murder regarding the death of Miss Engelhardt. Additionally, Mr. Dorian Taylor received an additional murder indictment for the death of Walter Riley, a 21-year-old. Apparently, allegedly, Mr. Taylor gave Mr. Riley some fentanyl pills. He originally thought he was going to get some Percocets. They turned out to be fentanyl pills, and he died. And coincidentally, prosecutors say Miss Engelhardt was also given fentanyl pills prior to her death. Now, let me tell you something, ladies and gentlemen. This fentanyl stuff is bad stuff, okay? Know personally of someone that was very similar situation, tried to get a couple of pills to make them feel better from an injury, and it turned out the pill was 100% fentanyl. Died almost immediately. Nothing anyone could have done to, in fact, save this young man. Why anyone should buy narcotics from the street is obviously stupid because you have no idea what, in fact, you are getting. And these days, it more than likely contains fentanyl because the fentanyl is being sent from China to Mexico, and the pills are coming across like you could not believe. They are flooding the American streets. And this stuff is more powerful than heroin, ladies and gentlemen. And people don't know what it looks like. They think they're getting something else, like a Percocet pill, when they're getting this stuff. It's dangerous, dangerous stuff. And as Mr. Taylor found out, that's right. If you distribute drugs to somebody and they die, you can be charged with murder. That's the law in just about every state in the union. Just common sense. Don't do the stuff, and don't take somebody else's prescription pills, and don't take anything from a street peddler. They don't care whether you live or die. Obviously, we'll give the spring break killers the presumption of innocence, but they have got a tough road ahead of them. Finally, our dumb criminal contestant of the day. Our dumb criminal contestant of the day is, well, Michael Lewis. He was suspected of stealing a vehicle. And in his escape from the police, he ran into a residence. And what did he do? Well, he tried to hide under a mattress. That's right, in between a mattress, underneath the mattress. The police followed Mr. Lewis into the residence because they can do that, giving chase. They don't necessarily need a warrant for that. And in this case, the officer had a canine with him. And so the canine unit detected the 59-year-old Lewis under the bed. And, well, let's say the dog grabbed onto his arm and a loud scream was let out by Mr. Lewis. Now, Mr. Lewis, you are our dumb criminal contestant of the day. Is it because you're stealing other people's things? Well, that is stupid, but I get it. Why would you think you couldn't get away with it? Because there's no penalty for taking other people's things anymore. Because people look at it and say, well, it's just stuff. Well, guess what? It's somebody else's stuff, and don't take other people's stuff without their permission. Well, Mr. Lewis, then you thought you were going to hide underneath a mattress? Are you kidding me? Would you think you were the size of a pea and no one would notice you? Come on. You are an idiot, Mr. Lewis. That's why you are a dumb criminal contestant of the day. And I think you may be a strong contender for the dumb criminal contestant of the week. All right, that's all we have for you today. Thanks for watching. Have a wonderful day, and we'll see you next time on Crime Talk.